Good morning. Are you Demarcus Senegal? And will your client waive the formal reading of the motion?
You will, Your Honor.
Mr. Senegal, in cause number 20-33924, I have a motion to revoke your community supervision. Shows that you were placed on probation November 30th of 2020 for the offense of deadly conduct discharging a firearm, a third-degree felony, and that was a 10-year term in prison that was probated for 6 years. Is that correct? It alleges that you violated your probation. Count 1 alleges that you provided a urine sample June 2nd of 2025 that tested positive for cocaine. And is that true or not true?
True.
Count 2 alleges that you provided a urine sample July 3rd of 2025 that tested positive for cocaine. Is that true or not true?
True.
Count 3 alleges that you provided a urine sample August 14th of 2025 that also tested positive for cocaine. Is that true or not true? And then count 4 alleges that you're behind in your court-assessed fees. And is that true or not true? Did you enter your pleas of true to counts 1, 2, 3, and 4 freely and voluntarily?
Yes.
And did you plead true to those counts because they're actually true? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? State tenders number 1.
No objection?
It's admitted. Any evidence that Mr. Senegal is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 2, 3, and 4 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time, revoke your probation. Reassess your punishment in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I have handed you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. I may have gone over that with you, but I don't think I started that in 2020. But because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm.
Where's Danny? That's you? Yeah. Okay, let's take care of Mr. Johnson here. Okay. 24 CR 1670. The state of Texas versus Danny R. Johnson Jr. That's you, sir? With you are here with Mr. Dusler, your attorney, and the state's attorney. There's a first amended motion to revoke unadjudicated probation here that we're going to be disposing. Was that your understanding, sir? Please raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth? So help you God. Does the defendant waive a formal reading of this first amended motion to revoke unadjudicated probation? Can we proceed in summary? Yes. In summary, this motion in 24 CL 1670, it was handed up. It was filed on 12/3/2025. Okay. Are we ready? Ready?
We have an agreement, yes, sir.
Oh, okay. This was just handed up just a couple of weeks ago. You have some fair amount of time to prepare for any disposition. Are you ready to move forward on this, Mr. Johnson?
Yes, sir.
Do you, and you've talked this thoroughly with your client, with your attorney, you've discussed it. Does the defendant waive any additional time he may have under the law to prepare on and move forward?
Yes, sir. We're ready to go.
All right. And we can proceed in summary.
Yes.
In summary, this first amended motion to revoke unadjudicated probation states that on March 3rd, 2025, in this court, you were placed on 10 years deferred or unadjudicated probation for assault on a peace officer. Is that true, sir?
Yes, sir.
Is it 6?
That'd be fine. Sure.
Number 6 in this first amended portion states that you violated your probation by committing the second-degree felony of robbery on or about October 21st, 2025 in Orange County, Texas, which is in violation of condition 1 of your probation order. Is that true? Are you pleading true? Are you pleading true to this voluntarily and because it is true?
Yes.
Do you understand that a voluntarily and knowingly made plea of true to one or more violations of probation, that is enough to grant a motion to revoke probation? Your probation can be revoked. You can now be found guilty and sentenced up to the full range of punishment, which is no less than 2, no more than 20 years confinement in prison. Knowing that, do you insist on pleading true today?
Yes.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true.
Yes.
The agreement has been reached where your probation would be revoked and you would be sentenced to 3 years. That's what that is, a 3?
Yes, sir. I'm sorry, the tablets, you stick
I know,
on the tablets and all this.
I know. We're going to make the Arabic pretty. So it's clear. Look like a snowman. Okay. 3 years in prison. Is that your understanding of the agreement?
Yes.
If I follow this, you have no right of appeal. Do you understand?
Yes. Yes. Yes.
Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney? Is everything true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence.
No, no.
Without objection admitted. Among other things, this states that you are waiving all rights of appeal if I follow this agreement, which I intend to do. All right. Anything else to add? No. I'm going to follow this agreement and find that there is sufficient evidence supporting this first amended motion to revoke unadjudicated probation, as the defendant has pleaded true to allegation number 6, committing the offense of robbery on or about October 21st, 2025 in Orange County, Texas, which violates condition 1 of your probation order, which is don't commit any offenses while on probation. And that is enough to, by preponderance of the evidence or greater, to grant this motion. Your probation is hereby revoked in this second-degree felony of assault on a peace officer. And I'm going to follow this agreement. Earlier in this case, you pleaded guilty voluntarily. You were mentally competent to do so. You understood and appreciated the consequences of pleading guilty, all when we placed you on probation in March of this year. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted in that hearing to find you guilty beyond a reasonable doubt. Now that your probation is revoked, I hereby find you guilty beyond a reasonable doubt of that second-degree felony. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 3 years. You will be given credit for all time you have served in accordance with this case. You understand what has happened to those?
Yes, sir.
Anything else?
No.
And then change it. Got it. All right, Mr. Van Wright, in cause number 24 DCCR 2485, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of injury to a child, elderly, or disabled individual. Sentence you in accordance with your agreement to a term of 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 15-23582, I'm going to find that you entered your plea of true to count 1 freely and voluntarily. Find sufficient evidence in that case to revoke your probation, and at this time, revoke your probation and reassess your punishment in accordance with your agreement to a term of 2 years in the Institutional Division of the Texas Department of Corrections. You will also receive credit on that for any time that you've been in custody that the law gives you the right to receive. The cases will run concurrently, which means together at the same time. I'm handing you, in each of those cases, trial court certifications that shows that these were agreements that I followed, so you waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can speak with your attorneys. All right, good luck to you, sir. You can go back with the bailiff. Thank you, Ms. Simmons.